talking about 85% of cases. 85% of cases, I believe, because I've not seen any of the statistics or any of those studies that have been referred to, but 85% of the cases where there is a court determination. What about the number of cases that are in fact settled out of court, and which is in fairness, and I mean, it's not like anybody here isn't surprised. I am not in favor of the bill, and it's because, based on my practice, 85% of my cases settle with parent complaints, and settle when we don't talk about visitation, which is a word I have always despised. I don't think any parent visits with a child. You have an access schedule with a child, but it's the cases that settle because the parents are willing to sit at the table and do so. The cases that don't settle and that end up in court are the ones that concern me, that there is a presumption that anybody has to overturn, and I think that it's the best interest of the child that the court should look for. And I guess what I'm interested in is what factors would you consider anyone needing to prove to rebut the presumption?
The choreography is slightly different, if you don't mind, so I appreciate the courtesy, but I'm going to let Dr. Colleen start. Thank you.
Good afternoon, Mr. Chairman, Madam Co-Chairman, and members of the committee. My name is Catherine Colleen. I am a licensed psychologist in the state of Maryland, and my practice is largely involved working with children and families in divorce and post-divorce situations. I want to thank the chair and the members of the committee for the opportunity today to speak in opposition to House Bill 1132, a bill which calls for the establishment of a rebuttal presumption of joint legal custody and a 50-50 timeshare of physical custody as the custodial arrangements that are in the best interest of the child. I'm here today not only speaking from my own experience as a practitioner, but representing the Maryland Psychological Association, a professional organization which I have been a member of for 20-plus years and have served in a variety of capacities, including president and chair of legislative affairs for many years. The Maryland Psychological Association opposes House Bill 1132 based upon both current social science literature and clinical experience derived from working with high-conflict families, post-divorce, or post-separation. The association has asked me and my husband, Dr. Paul Berman, who will be speaking after I, to speak on behalf of HEART, because Paul and I do have a joint practice that primarily focuses on high-conflict families in one context or another. So we do custody evaluation, we do mediation, we do supervised parenting visits, we do parenting work with parents, and parent coordination. I'm going to speak briefly about the social science literature, while Paul is going to talk more about the clinical experience. In sitting here and listening,
Thank you, Mr. Chairman, Madam Co-Chairman. My name is Paul Berman. I'm a licensed psychologist practicing in Townsend, Maryland. I'm also here on behalf of the Maryland Psychological Association. My wife and I actually had prepared some remarks. I thought she was going to say one thing, except she stole what I was going to say in response to the proponents. But I'll make a couple of brief comments. First, I too am confused. We have current law, based upon case law, which says that decisions should be made based upon the best interest of the child. So that's current law. Yet what I'm hearing is that we should be changing law so that it becomes what's best for the child, and that would be passing 1132. Except it appears that 1132 really is a parent's bill, as opposed to focusing on current law, which is the best interest of the child. I'm here, obviously, in opposition to 1132. I will make two other comments. One addresses the issue of equal access time, which has not really been addressed. Most of the focus has been on legal custody. The problem with equal access time is that it suggests that children of all ages should be treated the same. That is, a child who is 2 years old is no developmentally different, has the same needs as a child who is 10 years old, as a child who is 13 years old. That completely ignores all the science and all the literature that we're aware of. To suggest that a 1-year-old, a 2-year-old, or a 3-year-old child should spend equal time with both parents lies in the face of the current literature. What is being argued currently is whether a child at 1 or 2 years old can spend 2 nights away, 2 nights a week away from a primary home. What's being talked about here is equal time. Certainly from the literature, from my perspective, from the perspective of the Maryland Psychological Association, what's being considered in terms of equal time with both parents is harmful and destructive to children. What I'll also talk about and make a couple of comments, actually in response to a question, is another role that I'm involved in as a psychologist, and that is as parent coordinator. As parent coordinator, I work with parents who have joint legal custody, who are not able to jointly come to decisions with regard to their kids. So I am hired by the parents to essentially work with the parents, educate the parents about their children, and try to help them achieve a decision. If they cannot arrive at a decision, then I'm authorized to actually make a decision within certain parameters for these parents. Someone asked a question earlier about D.C.
Good afternoon, Mr. Chairman. My name is Craig Little. I am a solo practitioner from Townsend, Maryland, and my concentration is in family law. I've been an attorney concentrating in family law for 15 years. I am talking today as a representative of the Family and Juvenile Law Section Council. This is a committee of 20 attorneys from all around our state, and we represent the more than 1,300 family law attorneys that practice here in Maryland. The Family and Juvenile Law Section Council is opposed to the passage of HB 1132. As you know, we have felt this way now for several years, and we will be talking in support of the custody bill, or the custody determinations bill, that will be coming before this committee later on this afternoon. I think what I've heard today, or what we've all heard so far, Mr. Chairman, and the other members of the committee, is that there will always be horror stories, and it's unfortunate. There will always be abuses of the system, and I would contend to you that whether you pass this bill or not, if you did pass the bill, there will be abuses to that system. And there will always be unscrupulous attorneys who are going to take advantage of whatever system they're presented for the benefit of their client. But what I can tell you for sure, Mr. Chairman, is that there is a process that exists now in our state that does work. And that process involves that everyone who comes to court, especially in the larger jurisdictions, has the opportunity to engage in mediation. And that is that the two parties can sit down, talk about what the relative strengths and weaknesses are of someone who could be someone's parenting skills, or the mother's and father's parenting skills, to see if they can come up with a parenting plan that is in the best interest of the children. There is a process that we can appoint best interest attorneys who can come in and take a look at a situation, can talk to the children, talk to the parents, talk to the schools, talk to the therapists, and can really do a complete investigation of that situation. There are jurisdictions that can offer child access evaluations for free to clients who come in, parties who come in. A social worker who will go out and take a look at the children that are involved, both parties, and make recommendations to the court. There is a process that sits out there, and then if we have to go to litigate, and I think I would support what has been said here, is that about 80% of the cases that come before me do get resolved and are able to come to a resolution in terms of a parenting plan. But in the cases where they have to go to court, there is a judge who is sitting and listening to everything, who has had training in terms of family law issues, and who is not biased, because certainly it is the well-accepted public policy of this state that there is no maternal preference doctrine. There is no presumption of a good parent or a bad parent. But if, in fact, there are biases that people are being exposed to, we need to hear that. We need to take a look at the people who are making those decisions. And if there are biases anywhere along the system, I heard someone who said they were coerced into signing a mediated agreement. If those things are happening, we need to know, because then we need to fix the process. We don't need to fix the law, because the law is very well accepted in terms of the case law that is there. And in fact, as we'll discuss before, one of the ways that it is taken advantage of, or that it is abused, is the fact that the case law is scattered among the books. And we need to bring the case law together in one place where everyone, whether you are a pro se or whether you do have representation, can follow the case law, follow the law that we can now create a statute by that exists now, and that a process that exists now that does work. And so we would ask the Family and Juvenile Law Section Council respectfully request that we stand in opposition to HB 1132. Thank you very much.
Good afternoon. I'm Cindy Callahan. I'm a circuit court judge in Montgomery County. This is not a good day, obviously, to be a judge, but here I am. Many of you have seen me here before. I've been a circuit court judge for about 2 years. I have previously testified a number of times. I guess I could say this, my law practice for 25 plus years was as a family lawyer. And the last 2 years have certainly given me a different perspective. But what I would say is this, without any hesitation, the one thing that's clear is that every family is different. And every family is entitled to have a court make a determination on the basis of that family's needs. I've actually been authorized today by the Judicial Conference, which is the representative body of Maryland District, Circuit, and Appellate judges, to say that the Judicial Conference opposes House Bill 1132. I think one of the really important parts of this is that there is already a structure. The best interest of the child is what is supposed to inform the determinations that get made, and in fact, I believe it is. I think it's very hard when you sit through an afternoon like this and listen to people who are clearly hurt by what happened in court, clearly hurt by what's happened to their family, to put that aside to try to understand what the problem actually is. Some of the hyperbole that you've heard this afternoon, I think, needs to be addressed as well. It is absolutely not the case that there are 30-odd states that have a presumption of joint custody statutes. That is just not true. There are fewer than 10 that have such a statute. There are, however, about 38 that have a statute which provides that joint custody is an option. That's Maryland's law, not in the statute, but it's well established in case law for better than 30 years now. So the other thing that I think is really critical from the perspective of the judiciary is that this is a focus that is supposed to be on children. It's not only on children, and it's not only children who are important here. The family is important, but most of what we heard this afternoon really had precious little to do with children and mostly to do with parents and their rights. I think that the overall, my experience both in practice and now on the bench is that a presumption like this will not benefit children. It will not be in their best interest and will close the door on the analysis that needs to be made for every family about what will be best for that family going forward. And I almost made it to 3 minutes.
We look here today, and we have these people who are visibly hurting. And I've been a member of the Assembly for 21 years. I've been a lawyer for 30. There are a lot of people out there hurting. There's a lot of people expressing those same frustrations. And what I've heard from them is absolutely egregious. There's people, masters or judges, if they are conducting themselves in the manner which was so described, they have no business wearing a robe. They should be out. God knows where they should be. But tell me, how do you respond to that? These people are having their hearts ripped out, and I don't think they're coming in here lying and making it up. How do I respond to that? How do you respond to it?
afternoon, Mr. Chairman, members of the committee. Welcome to all the new members. We've been at this for a few months now. My name is Lori Ruth. I'm here on behalf of the Women's Law Center of Maryland. We are a member-based nonprofit organization that seeks to achieve equality in the law for women and children. I don't want to belabor the point. I agree with the opposition that's been voiced here today. I come at this from both a family law perspective, which is part of what the Women's Law Center does, and a domestic violence perspective. And in both instances, we oppose this bill very strongly. I just want to say one thing, which is the Baltimore County Bar Association right now is having this 6 months, it's actually only 6 times that you meet, training about child development as it relates to custody. And we've had 2 sessions. The first one was by Dr. Kleen, who is here today, and this week was by Dr. Alice Devoskin. These are, highly credible experts. I am not an expert in child psychology. I'm just a lawyer. But what I've heard over the 2 sessions that is so clear to me in the midst of all the scientific evidence, all the longitudinal studies, and everything that they've been talking about is that custody is not a one-size-fits-all proposition. You can't just pop into law. It should always be 50-50. Each child is different. Each family circumstance is different. Each people's needs for schedules is different. Each child's ability to cope with transitions is different. It's not always the case for a variety of reasons that they have gone over that it is the best interest of the child to have equal time with each parent. They talk about developmentally how much time a child needs to be with a parent to form a positive attachment and have a positive relationship. And in the scheme of things, I absolutely believe children should have the most time that they can with each parent as it is appropriate. So I urge you to oppose this bill. Thank you.